Further hearing in the appeal, Candey Ltd against Crumpler and another.
Yes, Mr. Holland.
My Lords, at the end of yesterday, I sought to explain what we submit the principle at play here is. That where, to summarise, where the parties have entered into an express agreement which covers the same ground as the lien or contains different terms, then there's no room for the common law or equity to intervene. And I took you to some authorities on that. We would say that's particularly clear in respect of solicitors' lien. Can I draw your attention to I've taken you to certain passages of Lord Eldon and Cowell and Simpson, but a particular paragraph in the judgment of David Richards, Justice David Richards, in the Clifford Harris No. 1 case, which is at the Authorities Bundle Divider 9, page 482. And it's paragraph 23. There's clear authority that a charge on the same asset as that covered by a lien or right to apply for a charge will displace the lien or right. There's displace, another epithet used as opposed to surrender or discharge or waive. The decision of the Northern Ireland Court of Appeal Kerry and Reyes, authority in respect of possessory and puts it on the basis of either waiver or merger. Waiver of the right to apply for a charge is the effect of groom and cheese right. There is an obvious inconsistency between an express charge and a lien or right to apply for a court to a court for a charge on the same asset. And that's particularly stark in the solicitor's lien. If you have, under the solicitor's lien, you have an existing equitable right, but you have a statutory right to apply for a legal charge from the court. And yet you have, it's difficult to see how you maintain that if you have expressly agreed a right to have that equitable charge. There is no need for the court to intervene because you've already got, by agreement what you could ask the court to grant you. And we say the key is thus incompatibility between the consensual arrangement on the one hand and retention of the lien on the other. And if I could ask you just to flick on to the Clifford Harris number.
If the express charge is a floating charge,
yes,
is it right to say it's on the same asset? Because the essence of a floating charge is it attaches to whatever assets conform to the description from time to time.
Well, in a way, the lien is a floating asset because it attaches to whatever the proceeds of the litigation it might be at the end of the day, as I understand. I mean, there may be some cases where, for example, it's clear what the proceeds are, but in most cases it might not be. It depends how much damages the client gets or what property is retained. My Lord, I was going to take you to the Clifford Harris No. 2 case, and it's just a brief passage at page 516, divider 10, page 516, paragraph 43 of the judgment of Mr. Nugee.
Could you use the electronic page number, please?
It's 516, I hope.
Thank you.
My Lord.
Thank you very much.
I'm unlike Lord Briggs, I'm a complete dinosaur. I'm working completely from paper, so I hope I've got the same page numbering. And it's simply this. We'll come back to this when I deal with my next point, because this is a case where exactly the same point as my learned friend appears to make, certainly in his written case, was made to Mr. Nugee. But he says there, midway down the page, and he's dealing, just to put it in context, with Ree Morris. And he says, at paragraph 43, this is clearly not what the majority thought. In my judgment, what the majority meant by inconsistency is that there's some feature of the security which is incompatible with the lien, such that the two rights cannot sensibly have been intended to subsist in parallel. And we say that's the test. It's a question of intention. And can it sensibly be suggested that the two rights are intended to subsist in parallel? And we say this is why the courts have repeatedly said that there are a number of clear examples or situations in which absent express retainer, the courts have held that, say, absent an express term, the lien has been waived. And the first, of course, is the new security over the same property. And we would say this is a paradigm case of implied or inferred waiver. The obvious inference, absent express retention, is that the new charge is intended entirely to replace the lien. Ask yourself, why would the parties intend the solicitor to have two security interests over the same property? And we set out in our written case numerous examples in which courts have held that security being taken over the same property as is covered by the lien has waived it. There's examples in respect of unpaid vendors' liens. We cite the case of Bond and Kent. You have that at divider 42, page 958 of your authorities bundle. Capper and Spottiswoode, well, Bond and Kent is 1692, Capper and Spottiswoode is 1829, and that is at divider 47, page 1011 of the authorities bundle. And just dealing with unpaid vendors' lien, we say that it's most clearly explained in Burston and Spearway, and I'll take you to that if I may. It's at divider 7, page 441 of the authorities bundle. It's a judgment of Mr. Justice Walton, and if I can ask you to look at page 445 to 6. And again, this is the unpaid vendor's lien, and one's dealing with a circumstance where the vendor has agreed an express charge over the property to secure the payment of the purchase price. And it starts letter F. And my lords, I was going to, rather than read it out, can I invite my lords to read either now or at their leisure from it's page 445 letter F down to 446 letter G. Which page?
Yes.
I'm grateful, my lord. You'll see the passage there where he says it strains ordinary credulity to assume. But that's the test, is the intention. If you take a charge over the whole of the property, it strains ordinary credulity to suggest that the intention is to retain another parallel security, which is implied by equity over the same property. And those principles have been applied in the Court of Appeal and the House of Lords in this jurisdiction, in Capital, Finance and Stokes. That's at divider 8 of the authorities bundle, page 452. In Arakpo and Manson, that's the passage we looked at yesterday in the judgment of Lord Edmund Davies, and in Nationwide and Ahmed, which is at divider 86 of the authorities bundle, page 1690. It's been applied also in the Irish case of Aluminium Shopfronts, which we cite, and that's at divider 36, page 902 of the authority. And we would submit that the same principle has been applied in respect of the Curry and Ray is the Northern Irish case, which you've already looked at. That, I accept, is a case of possessory lien, but Groom and Cheesewright is a case of equitable lien, and that was a case where there was security over the property preserved, and over other property as well, if you look at the facts of that case. Re Morris, again, my learned friend took you to the passages in Re Morris. It's at divider 20, starts at 623, but the passage at 627, again, in which Lord Justice Buckley starts off his judgment, where a solicitor is entitled to a lien, takes from his client security upon property already included in the lien. That's one of the pristine examples which at the start of his judgment he suggests indicates that the lien has been waived. The Twigg-Farnell case, my learned friend relies upon, well, there's 2 points about that. I'll come back to that briefly when we're dealing with the solicitor's fiduciary duty, but that was a case where A, the solicitor and client relationship had clearly terminated some years ago, but B, the solicitor had a private security as judgment creditor. So it's not technically, we would submit, a case where the solicitor had security over the same property, because any right to the contractual right to costs had merged with the judgment debt. And again, it's an example set out in Clifford Harris number 1, that is taking a charge over the same property. And we say the inference of waiver is stronger with the solicitor because, as I pointed out, the parties have by express agreement done what the solicitor would otherwise have to ask the court to do under Section 73. And we also submit that there's no reason in principle why it should matter that the new security not only includes the property which would be the subject to the lien, in this case the proceeds of the London litigation, as well as other property. The inference to be drawn, we say, is the same. There's no principal distinction between a case where security is taken over only the property which would be subject to the lien, and cases where the security is over not only that property but other property. Can I just make it clear, I've taken instructions, I may have misled unintentionally USD, so far as Campion Maverick in this case is concerned. As I understand it, there was a valid charge to Campion Maverick. There was a valid legal charge. Secondly, there were funds advanced to PHRL, which Campion Maverick claimed had come from it. It turned out, however, that those funds had been effectively stolen from PHRL by Campion Maverick. And that is why, following investigation after the liquidation, the liquidators have declined to say that Campion Maverick has any valid debt. The point to make is that as at 2015, when the fixed fee agreement and the deed of charge were entered into, that had not been ascertained, and there was at that time, as recognised expressly in the deed of charge, a security, an express security of charge to Campion Maverick. Can I deal with now, just, I think it's a logical part. My learned friend pointed in his submissions to the passages in the Barclays Bank case, the judgment of Lord Justice Millett, where he dealt with the case of Kettlewell and Watson. And that was the case where Lord Justice Millett had said, well, if you cited passages from that case, it's at page 4, divider 3, page 415 to 417 of your authorities bundle. And that was a case where Lord Justice Millett, having cited at length from that case, then says, well, that was a case where there was a subordination of the equitable lien that was a vendor's unpaid vendor's lien, and that was the case where the property was put in the hands, or was sold and put in the hands of agents to subsale, and Lord Justice Millett in that case, having analysed the facts, says, well, that was a case where the lien was subordinated, and I think what my learned friend did was point to paragraph 5 of the deed of charge. That's the effect of this. It's I think maybe paragraph 7. We are effectively subordinating the lien. Well, my lords, one has to be very careful, we would submit, about saying that the lien can be subordinated in that way. First of all, the lien is an equitable lien. It arises by implication of equity, and it's akin to salvage. It is a first charge over the assets. And we would submit that if you alter that priority, then what you've got is not the lien. It may be some additional different security, but it's not the lien. Secondly...
Why? If the essence of a lien is that it's an equitable charge,
yes,
created by operation of law as the result of a certain type of litigation retainer,
yes,
never mind which type, it's a matter of other cases, where there is an entitlement to fees and this credit is given, why can't the parties agree it should be subordinated?
Well,
without losing its nature as an equitable charge?
You can agree that I will have an equitable charge which is subordinated to a pre-existing agreement, but then it ceases to be the lien implied by equity and simply becomes an equitable charge agreed between the parties. Because the lien is, my learned friend makes the point, and we agree, the lien is treated as salvage. It automatically comes at the top of the waterfall. And if you start by agreement to say, well, it's coming lower down the waterfall because we will agree to subordinate whatever rights we might have in equity to the fact, and it ceases to be a lien, it becomes a separate equitable right. I mean, on the facts of Kettlewell and Watson, and as the judge makes clear, if you look, it's very much a decision on its own facts, because Lord Justice Millett quotes at length from the judgment in that case and says on the facts. But that was, the equitable lien was actually subordinated to other equitable liens. That's the point. They were subordinated to the rights of the sub-purchasers, who I think had equitable rights. That's what the report suggests or says. And it's one thing to say, well, I might subordinate my equitable right to another equitable right. It's quite another thing to say, as here, I'm subordinating my equitable right to a pre-existing legal charge. In any event, we would submit that even if it's right that you can technically subordinate the lien while it exists as the lien without creating effectively a new equitable right, even if you can do that, on the facts of this case, it's not done, because I'll take you through, hopefully very briefly, the express terms of the deed of charge and the fixed fee agreement, and it's clear, we say crystal clear, there was absolutely no intention to maintain any pre-existing right that the solicitor might have had. The second clear example where courts have held that absent express retention, the lien has been waived, is the new security with a different priority. Now, there was some discussion between Lord Briggs and my learned friend, Mr. Lord, yesterday about repugnancy and inconsistency. Repugnancy is not required, it's inconsistency. But we say that this almost goes as far as repugnancy. Where the parties agree that the solicitor is to have security which ranks at a lower level of priority than the equitable lien, they cannot sensibly be taken to have intended that the solicitor should retain his lien which ranks at a higher level of priority. And that's Groom and Cheese right, and that's a case where the assignment, the technical effect of the assignment was that the trustee came at the top of the waterfall, and the solicitor was attempting to say, well, no, I come before the trustee, and the court said, well, no, that's inconsistent. McClure and CRF is a Northern Ireland case, which is at 81 of Divider 81 of your authorities bundle, page 1614. I don't intend to take you to that, but I can if you wish. And we say the blindingly obvious point here is that having expressly agreed to a charge which ranks below Campion Maverick, Candey cannot be heard to say at all times it retained another security, parallel security interest, which ranked above Campion Maverick. And it matters not, we say, whether the fixed fee agreement or deed of charge was expressly intended to be a fixed or floating charge. The fact is, whatever it was, and I've already made submissions that the labels attached to the parties by the parties are irrelevant. But even if they are relevant, this was whether it was a fixed charge or a floating charge, it was intended to rank below Campion Maverick. The third clear example is the different rate of interest, and we deal with that at paragraphs 52 to 57 of our written case. There are a number of cases in which the courts have held that a new arrangement between a solicitor and a client, which involves a right to interest, is inconsistent with any intention to continue an arrangement which had no such right. I mean, we say, one, the equitable lien doesn't protect interest at all.
But even if it's part of the contractual terms of the retainer?
There's some doubt about that, we would say, but it doesn't matter here, because prior to the entry to the fixed fee agreement and the deed of charge, there was no contractual right of interest, or the contractual right to interest varied or changed as a result of the fixed fee agreement.
But I mean, take a situation where retainer on a Monday automatically creates a lien. Yes. And on Tuesday, the solicitor and the client agree that interest should be payable on the fees. Yes. Why doesn't the lien capture whatever is agreed by way of remuneration, which includes contractual interest?
It may do. I don't have to go that far for my present purposes, but it's simply, I think it derives from the definition in section 73, which is costs, and costs not expressly defined to include interest. I think that's the point.
But is the extent of the equitable lien controlled by section 73, or does that come along afterwards to operate as a means of enforcement?
It may do, but it may be a parliamentary reflection of what the Parliament thought the lien covered, in that it was intended to give the solicitors a right to apply for a charge to enforce legally what they had at equity. And it would be strange if Parliament thought, well, you can go to court and get an express charge under section 73, but that express charge doesn't include, it doesn't by definition include interest. I say I don't have to. There are some dicta which say, you know, the key is interest which had not previously, to which the solicitor had not previously had a right. I accept that, but I don't have to go that far. I mean, the point is, if you look at the supplemental, I think it's the supplemental key documents bundle, you will see it includes Candey's terms and conditions, I think. And the point about the normal terms and conditions which applied before was that there was a right to interest, but there was no express rate. It says clause 3, which I think is page 3 of your supplemental key documents bundle. We will invoice you on a monthly basis, and we require our invoices to be paid within 7 days of receipt. Thereafter, following 7 days' notice, we may suspend work on your matter until payment is received and charge you interest. You are entitled to object to our invoices and apply for an assessment apart from the Solicitors Act. We are entitled to retain all papers until our fees are paid in full. I'll return to that passage shortly. But so there was a right of interest, but only default and no particular rate. Whereas if you look at, I'm trying to find out, I've got it marked up elsewhere.
That would be a reasonable rate, would it?
Yes. Well, I don't have to go there, but it's not. The point is that the fixed fee agreement expressly says they can charge at 8%. And I think it's... So there is an alteration of the rate of interest.
You're not going as far as saying that if you have a retainer on a Monday with interest at, say, 5%, yep, and then the parties agree to increase the interest rate on a Wednesday as an amendment to the contract of retainer, that somehow the lien goes because they've amended the contract of retainer?
No.
And the lien would cover, would it, the increased rate of interest?
Well, all of these cases are where security has been taken. I mean, I think what's been held is if you have, say, the possessory lien, if you've got a possession of the documents and then you enter into security with a higher rate of interest, I think that's the key.
Yes, but here what happens is that the high rate of, I mean, the case being made against you is that the high rate of interest is contained in the retainer agreement, not the security.
Oh, that's the case. I mean, but in that case, you have to separate out the fixed fee agreement from the deed of charge. And you have to say that that's the case, is that despite the fact that they're entered into on the same day and that they cross-refer to each other, the fixed fee agreement is the retainer and the charge is the security.
Yes.
And therefore the charge says nothing about interest. It's the retainer.
It says you get whatever interest is recoverable under your retainer.
Yes, but you have to then, so we say you can't, in that regard, you can't separate out the two. They're part of a package. There's no evidence that Candey would have entered into the fixed fee agreement without the charge and vice versa. And therefore it's unrealistic to, in this circumstances, to say, well, and this is what the judge did, but the Court of Appeal, we say, rightly rejected that. So you have to look at the deed of charge and the fixed fee agreement that were actually entered into on the same day between the same parties and cross-refer to each other as a part of the same package, and therefore there was no right to 8% interest prior to the 21st of October. After the 21st of October, there was a right to interest as part of the overall package, which included the fixed and floating charge, or the charge that was in the deed of charge. And that, we say, falls clearly within the mischief at which the courts have said, or falls clearly within the principle that absent a retainer, that's a difference which matters, and it's a difference which indicates that the lien was not intended by the parties to survive. It's not quite as, I have to say, it's not quite as clear as the charge over the same property or a different priority, but the courts have held quite clearly that's what it's clause 4 of the fixed fee agreement, 8%, and that's 8% from the date when the fixed fee becomes payable. But there's a string of cases, Robards and Jeffreys in 1830, that's divider 23 of the bundle, 682 at 685. Brettel and Burdett, 1864, divider 44 of the authorities bundle 964. Taylor and Stileman, the case you looked at yesterday, learned friend, that's divider 26 at 730, 731 and 733 to 4. Ree Morris, again, case you looked at yesterday, divider 20, 623 at 627. And both judges in the Clifford Harris case, it's Justice David Richards in Clifford Harris number 1, divider 9 at 474, at paragraph 30, which is at 484, and Clifford Harris number 2, Christopher Nugee, divider 10, page 490, paragraph 51 at 520. So it may not have been decided at this level of court, but there's a consistent stream of authority dating back nearly 200 years in which courts have held that absent express retention, an arrangement which provides for a new or different rate of interest is one that is deemed, the intention of the parties said, cannot have been to retain the lien in parallel. We also cite clear example number 4, which we say was a different mode of enforcement. And my learned friend dealt with this. He took you to the brief passage in the the Privy Council in the Bank of Africa case, which is at divider 2 of your authorities bundle, page 402 at 405. An agreement giving a creditor new and special powers with respect to part of the subjects covered by his original lien. And we say that's the case here. If, as this is a floating charge, then it contains, by I think section 110 of the Law of Property Act, a right to appoint a receiver out of court. And that is a right which Candey threatened to use on a number of occasions. And we've cited in our written case the various pages in the core bundle where those emails are. We accept that...
that would surely mean that any security is going to be inconsistent with the lien. Because all the lien entitles you to do, apart from sue people who act inconsistently with it, is to go to court and ask the court to help you enforce it. Whereas virtually any kind of express security contains some rights of enforcement, whether it's a power of sale or a power to appoint a receiver. Almost invariably, express security contains enforcement powers that go beyond what you can do without coming to court under your lien.
Yes, I suppose what if you granted a security over a completely different asset? Then it may be that it wouldn't matter. For suppose the client is suing for damages, a case which has nothing to do with the client's residential property, and the client, in order to secure the fees, grants security over the residential property, which would include those various rights. I suppose it might be said, well, that's got nothing to do with this. You can sensibly retain the lien in those circumstances, despite the fact that the new security has rights which you don't get under the lien. My lord, I'd accept that. But the final point we make, I suppose, is that there is a cumulative factor here. We've said paragraph 84 to 85 of our submissions. We say, and we cite the case of Burston Finance and Spearway, you can take into account a number of different factors. And my fallback position rapidly is that, well, if you have security over some or all of the proceeds and something else, and that security grants you additional rights, then that is an inconsistency which either by itself or cumulatively with other inconsistencies would indicate that the intention is not to retain the lien. My lords, I hope that is an answer. It may not be a satisfactory, a wholly satisfactory answer, but to my lord's point. I intend to move on now to what I say was the third misconception at the heart of, you remember back yesterday afternoon I said there were three misconceptions, the heart of the appellant's case. And this is that the basis for waiver of a solicitor's equitable lien is founded on the solicitor's fiduciary duty to advise his client. And here we have to deal with the interaction between, the one hand, the waiver of liens in favour of parties who are not solicitors, and waiver of lien of parties who are. It's important in my submission to look at the windmill at which I'm tilting here, because it wasn't entirely clear from a learned friend's oral submissions that he was maintaining the point. But if you go to ground one of the appeal, which you will see is at divider 1, page 32 of the core bundle, you will see it's clearly set out. Independent legal advice. Lord Justice Rhodes, McComb, with whom Lord Justice McComb and Lord Justice Moylan concurred, was wrong to find the principles by which a court may infer that by taking additional security, a solicitor intended to waive his equitable lien apply in this case. The approach to waiver in cases concerning a solicitor's equitable lien is founded on the solicitor's duty to advise his client when taking additional security. Those principles do not apply where a solicitor expressly informs the client that he's not advising the client in relation to the transaction and requires the client to take independent legal advice, and where the client expressly confirms that it's taken independent legal advice and accepts that the solicitor is not providing advice to it in respect to the transaction. Now, that appears to be saying that in circumstances when one's dealing with a solicitor's lien, well, one sets aside the rest of the learning.
It's clearly not what Mr. Lord was saying yesterday.
No, but I
just wonder if there's anything between you on this point.
Well, I'm not sure there is, but it was something was said. I mean, I thought this is why permission was granted. We thought this was the whole point of this, the assertion that somehow solicitor's lien was to be treated differently because of the fiduciary duty, and the principles go out the window. And I'd assumed that the case being advanced, and it's made clear at paragraph 44 to 46 of the written case, was that it doesn't matter. The principles of waiver don't apply elsewhere, don't apply, we thought was being said here, because it's purely a question of looking at the solicitor's fiduciary duty. And if the solicitor has said to the client, go off and take independent legal advice, that's sufficient without more. We'd rather thought that was the whole point of this, but listening to my learned friend yesterday, it doesn't appear to be the case. But that's why I'm setting up this, Aunt Sally, because it's clearly in the grounds of appeal, and it's clearly in the written case. Say paragraphs 44 to 46, 57 and 119 appear to us to say that you set aside the principles of waiver applied elsewhere and purely look at the solicitor's fiduciary duty. And if the solicitor has advised the client to take independent advice, and that client has taken independent advice, that is sufficient without more. Now, I'm not sure that's the case that's presently advanced, but it was advanced in the ground of appeal and was advanced in the written case. But, my lord, we, of course, say that that's not the case. Whilst, of course, the nature of the solicitor's duty to his client is highly relevant, in our submission, the underlying basis of waiver or abandonment of a solicitor's equitable lien is the same as that which is applicable in respect of other liens. And we've already explained that. But what is the effect of the solicitor's fiduciary duty? We say the effect of the solicitor's fiduciary duty to his client is not to completely alter the basis of the doctrine of waiver, but rather it is to superimpose onto those principles additional requirements which make a court readier to find waiver of a solicitor's lien than of other liens. We say the key is to focus on that passage in the judgment of Lord Justice Millett in Barclays Bank and Estates and Commercial, which I took you to yesterday. It's the one where he cites a passage which says the burden is on the person asserting that the lien has been waived to prove it is such, and that what is required is clear and manifest intention that the lien be waived. And we would submit that the effect of the solicitor's fiduciary duty in the case of a solicitor's lien is effectively to reverse that. The burden is on the solicitor to show that despite any new arrangement, he or she has retained the lien, and that what is required from the solicitor is to show a clear and manifest intention that the lien has been retained. And we would go as far as to say, and I think I made the point yesterday, that in most cases the solicitor has to expressly make it clear to his client that he intends to retain the lien. Now, whether he does that by express words, I retain my lien, or whether he does it in so many words that indicate clearly that he retains a pre-existing security which he already had, may not matter.
But is the trigger for that burden on the solicitor entry into any security or any inconsistent security? I thought that was the point of that was being explored during Mr. Lord's careful analysis of the authorities yesterday.
I think it's inconsistency. Our submission is that the test is that effectively summarised by Mr. Newgee QC, which I've already taken to you, that there has to be some inconsistency.
If you accept that burden is imposed on the solicitor only, but when there is inconsistent security taken,
Yes.
I'm really not sure what's between you.
Well, nor am I. But
Because I think it's just about, subject to express or implied, I think Mr. Lord accepts that if there is inconsistent security, then the solicitor has got to demonstrate that the lien has nonetheless been reserved.
Yes. Yes, and clearly...
There may be an issue about whether he can do that by express reservation only or whether it can be implied.
Yeah, well, we would say, using the words of Lord Justice Millett, the solicitor has to make it clear and manifest to the client. That's I'm just using the words that Lord Justice Millett, because and I'm effectively reversing the burden which Lord Justice Millett analysed was on the client or the person asserting that liens waived in that case. Now, clear and manifest might not be words that appeal to this court, but the idea is that's the idea. And
the difference appears to me at the moment to be that you advocate for an express reservation and an unequivocal reservation.
yes,
And I understand the appellant's case to be that it can be implied.
yes. It's difficult to know what I didn't understand exactly what my learned friend, the point he was making, but that may be more me than him. But we would say there has to be, as Lord Reid, I think, made the point yesterday, that there has to, the solicitor's fiduciary duty, the special nature of the relationship between the solicitor on the one hand and the client on the other, which is loosely called a fiduciary relationship. Although you are a fiduciary because you owe fiduciary duties and not the other way around, as I think Lord Justice Millett pointed out, and I think it's the Mothew, in the Mothew case. But nevertheless, that relationship is one which there's a special fiduciary, I'll call it that, and that has to be reflected somehow. It's different, but to the relationship between a vendor and a purchaser, or between an innkeeper or a cobbler and his client. And so the court has to ask itself how that relationship impacts on the doctrine of waiver. And the courts have found it difficult. My learned friend took you to the Taylor and Stileman case and the Ree Morris case. I mean, if you look at what Mr. Nugee said, the same submission was made to him. If you go to divider 10 of your authorities bundle, and you look at paragraph 30.
Page?
I'm sorry. It's page 506.
Thank you.
And he records the submission made to him by counsel on behalf of the client in that case. Mr. Marshall's primary submission was that the taking of any alternative security of substance and value without an express reservation of the solicitor's existing rights would be sufficient for the waiver, there being no further requirement for inconsistency. He said this was supported by the rationale for the waiver principle found in the authorities. This is the duty of the solicitor to tell his client if he intended to retain his lien. If he failed to do it, it was assumed that this was because he did not intend to do so. Now, I'd assume that that was the submission being made, and he repeats that at paragraph 38, which is at page 513, where he says, Mr. Marshall relies on the repeated theme in the case that an important consideration in the case of solicitors is their duty to explain to their clients their rights and liabilities, the effect of what they're doing. And then what he concludes at paragraph 39, at page 514, having discussed various cases, including Taylor and Stileman, Ree Morris, Bank of Africa, and just about a third of the way down the page, dealing with the judgments in Reed Morris, both expressly said that solicitors were different from other lien holders, see the passage cited above, but did not regard this as entailing the consequence that it was unnecessary to find an inconsistency. Rather, it seems to me they regarded inconsistency as essential in the case of solicitors as in the case of other lien holders, but somewhat more readily to be found in the case of a solicitor's lien than the case of other liens. And if one stands back from the argument for a moment, it's difficult to see why, in principle, solicitors should be held to have abandoned lien by taking security was in no way inconsistent with it. Therefore, reject Mr. Marshall's argument at this point. But one sees there the judge trying to find, well, how exactly does the solicitor's fiduciary duty impact?
Well, he finds it in paragraph 40, doesn't he?
Yes.
If there's an inconsistency,
that's right.
The solicitor will be regarded as having waived his rights unless he expressly reserves them.
Yes. Yeah. And that, we say, jumping somewhat, is what the twig was said by Lord Justice Sheeman in the Twig Farnell, the Twig case. If I just jump to that, 27. At page 739. He says this, I agree. The reason for the inference during the continuance of the solicitor-client relationship that the solicitor intended to waive his lien when taking further security is this. It is assumed that solicitors will intend to act in accordance with their duty. Their duty, if they're not waiving the lien, is to inform the client of what they're doing. If they do not inform the client, it is assumed in the absence of evidence to the contrary that this is because they are waiving the lien. For that reason, which is no different from the substance expressed, my lord, I would dismiss this appeal. And that's it in a nutshell. Now, my lord, I was going to make... my learned friend drew your attention to the and it's probably worth going to, the paragraphs 17 and 18 of the judgment of Mr. Justice David Richards in the first Clifford Harris case, and that's in Divider 9. Because it's page 478. I think my lords have read this, but he says right at the bottom of that page, paragraph 17, what emerges from the authorities if there are two key questions as reflected in the passage cited above from Cordery. Is the security inconsistent with the solicitor's rights common law under section 73? And because of the fiduciary relationships between them, did the solicitor inform the client that he was reserving those legal rights? If it's inconsistent, it will be taken to waive the solicitor's other rights unless he's reserved them. And there's a passage midway down paragraph 18 where he says it's about 10 lines down. I'm sorry, my lord?
There must be communication by the solicitor.
That's all he...
Is that the bit you're
The sentence beginning an absence of an intention to waive is insufficient.
That's right.
Yeah.
There's no evidence that any time taking a legal charge, any party gave any thought to Clifford Harrison over any recoveries. An absence of intention to waive is insufficient. There must be communication to the solicitor of the client of his intention to reserve his rights. The waiver, if any, occurs at the time the charge is taken. It's also interesting to look at how he deals with the independent legal advice, because on the facts of that case, the client had actually been sent off to take independent legal advice. And he just says a few lines down, as to the second point, the absence of any recovery in litigation at the time of taking the charge does not, as Miss Harman accepted, preclude a waiver, groom and cheese right. In my view, it cannot affect the question of waiver, although it may explain why no one discussed it at the time. Future rights can be waived just as much as present rights. As for legal advice, the relevant facts are very much in dispute. However, even if Clifford Harris & Co. establishes its version of events, legal advice to Mr. and Miss Sullivan cannot take the place of information from Clifford Harris as to whether they intend to reserve their common law and statute rights. There's no evidence of any advice on this point to Mr. and Miss Sullivan, but on the authorities, the correct advice would have been that if there was inconsistency, Clifford Harris & Co. would lose their rights unless they expressly reserved them. That, we say in a nutshell, deals with the independent legal advice point, and I'll come back to that. But, my lord, if it is, at one stage yesterday, my learned friend isolated the two questions and then said, well, the independent legal advice point deals with the second of those questions. But even if, which we say is not the case, even if independent legal advice neutralises the obligation on the solicitor to inform the client that whether or not he intends to retain his lien, it still leaves the inconsistency point. Therefore, if the law is, and we say it is, that in addition with a solicitor fiduciary duty, there has to be inconsistency as any other lien, but the solicitor has to expressly inform the client whether or not he's retaining his lien. If instead of doing that, he sends his client off to get independent legal advice, put it at its highest, as I understand it now, the appellant's case is, well, that somewhat neutralises the fiduciary duty point, but it still doesn't deal with the inconsistency point, we would submit. But we say it doesn't. Independent legal advice by itself is not good enough. There are authorities which we say clearly support this Justice David Richards' view that it's not good enough simply to say you need to take legal advice and that's it. The independent legal advisor, albeit maybe more learned in the law, is in no better position than the client when faced with, for example, a document like the fixed fee agreement and the deed of charge in this case. The independent legal advisor is in no better position than the client. Well, I'll come to that. I've taken myself somewhat out of...
It's not relevant to the question of inconsistency.
No, it's not. Well, as I understand it, I'd understand the case that it was, but I now understand the case as it isn't. Well, my lord, I had a lengthy passage, or somewhat lengthy passage, as to the nature of the solicitor's fiduciary duty. My lords, I don't think I need trouble you with that. There's a series of cases. We deal with it in paragraphs 58 to 80 of our written case. There's a general duty of the fiduciary and the specific duty of the solicitors. Perhaps worth looking at McMaster and Byrne, which is at divider 19. That was a Privy Council case.
Page?
It's page 614, my lord, I'm sorry. It's not a solicitor's lien case, it's a dealing case, but I would draw your attention, I don't want to take you to it, is to the passages at 619, letter H, on the first question, their lordships, down to 621 at letter H. And there you will see their lordships cite from the judgment of Mr. Justice Parker.
Is this an undue influence case?
Yes, it is. Well, it's not yes, it's a case of dealing with the client. It's not but it emphasises the nature of the duty. And Allison and Clayhills is an earlier case, which again is not a solicitor's lien case, but it emphasised the nature of the duty. And we would say there are 3 points which both those cases bring out. One is that the duty is on the solicitor to communicate all material facts within his knowledge. Secondly, the onus is on the solicitor to prove that this was done. And thirdly, the fiduciary duties may survive the termination of the contractual retainer. And that was the case in both Allison and Clayhills and McMaster.
But that doesn't arise here.
Well, my learned friend said it does, because they say, aha, we owe no duty. Look, you recite, you've got independent legal advice on the fixed fee agreement.
But they're not suggesting the retainer terminated. It may have been replaced by a new one, but there was no point in...
No, exactly. Our point is whatever the exact legal position was, the contractual position was, the fiduciary duty continued. It pre-existed the fixed fee agreement and the deed of charge, the whole point of which was to allow the solicitors to continue to act for the client, and therefore any fiduciary duty continued, whatever the nature of the contractual obligation, because it might be said, well, look, we sent you off to Mr. Frayne Bell to take advice on on the fixed fee agreement. Therefore, we owed you no contractual duty to advise on the nature of the fixed fee agreement. But that doesn't terminate the fiduciary duty, which, as exemplified in McMaster and Alison Cahales, can continue despite that.
The approach Lord Cohen seems to take is to ask whether the confidential relationship continues. And I suppose you would say the implication of the new retainer is there is a confidential relationship that's continuing.
Yes. And the whole point of the new retainer was to allow that to continue. My Lord, the same points are made in the Taylor-Stileman, Lord Morris, and Morris case. And again, those emphasise, one, that the same principles as with other liens apply. Two, there's the higher duty on the solicitor. And three, the solicitor must expressly inform the client. So there's nothing we say in the judgments in Re Taylor and the majority in Re Morris which would undermine or in any way differ from what I've said. And I say, our primary case is that the solicitor must expressly inform the client that he or she intends to retain the lien. You might argue about whether, well, what express means. I mean, do you need to say, I intend to retain my lien, or can you use so many words? I would submit that, yes, you can, provided what is said clearly explains to the client what is being done. By the way, I intend to retain any security rights which I had prior to this agreement. That would, of course, then lead on to a duty when the client says, well, what do you mean by that? To say, my security rights include what's known as the solicitor's lien, by which I have effectively a first charge over the proceeds of litigation. And that's the point. The minute you start setting out what you need to do is the duty on the solicitor to explain to the client. I mean, it may be that that's where independent legal advice will come. If you have an agreement which says, I hereby intend to retain any pre-existing securities which I had prior to entering into the order, any pre-existing security, whether expressed or implied by law prior to this, then you send the client off to another independent legal advisor. Then that independent legal advisor might say, well, might seek to explain or seek to ask questions of the solicitor. What do you mean by that? But there's nothing of that sort here, we would say. But that may be what is meant. It may be a difference without meaning. But we say, in clear words, the solicitor has to expressly inform the client that he's retaining his lien. There are authorities as well which deal with the effect of independent legal advice and clearly we say exactly what Mr. Justice David Richards said in the first Clifford Harris case. There's a case called Barnard and Hunter, which is divider 4 at 421 at 423. There's a case called Re Beard, which I'll come to. There's Demerara Bauxite, which is at divider 13, page 562. And there are the two Clifford Harris cases. I've already cited paragraph 18 at divider 9, page 471. And Mr. New GQC deals with, again, at divider 9, divider 10 rather, 496, paragraph 8. But Re Beard, again, if you want to read it, it's divider 5.
Page?
Sorry, divider 5 page. It starts at 425. And it's page 429 to 430.
Sorry, which court is this?
I'm sorry?
Which court is this?
It's the New Zealand Court of Appeal.
Oh.
I was about to make that clear, so I wasn't.
17.
And it's simply the passage, again, it's not a solicitor's lien case, but it's a dealing case. And if one goes to, it's the passage before entering in upon the facts in detail at 429, down to the quote from Holman and Loynes, which is about a third of the way down, 430. And it's 432, having set that up, the middle paragraph. Now, the requirement that the seller shall be placed at arm's length is not satisfied by merely passing him on to another solicitor to advise him whether or not the documents drawn to carry out the bargain are properly give effect to the bargain, or to ascertain whether he's willing to carry it out. The advising solicitor must be placed in possession of all the facts so as to be able to advise on the propriety of the bargain itself, and not merely of the documents by which it is carried out. Barrett, Hunter, Gibbs, Daniel, Wright, Carter. It is moreover incumbent on the purchasing solicitor, as already indicated by Lord O'Hagan's judgment, McPherson Watt, to see the advising solicitor is put in possession of that essential knowledge of the facts. And we say that's is applicable to the law in England as it is to the law in New Zealand, and it's exactly what was said by Mr. Justice David Richards and Lord Justice Sheeman. I accept that in Re Morris, Lord Justice Buckley clearly said in those passages at 627 and 629 that you could have an inferred retention. My lords will recall, I think Lord Briggs was debating that question with my learned friend yesterday.
But are there any examples of that?
I don't think so. Not that I've found. I mean,
somewhat at odds with Lord Elverstone at 625. It's express duty to give express notice to the.
Yeah, there are passages which we say that the burden of the majority of legal statements would clearly say that in the case of a solicitor it has to be express. But it's clear, I think, that Lord Justice Buckley would be prepared to was prepared to countenance an inferred retainer. We would say you have to be very careful at doing that, and I've already made my submissions as to what we say the test is and should be.
Yes, I mean, the trouble is that the issue in that case was not whether there was an implied reservation.
No. My Lord, I'm going to move on now, my Lords, to look briefly at the documents in this case, because it's my learned friend's case, and has been throughout, that there was an express retainer or an implied retainer by looking at the terms of the documents. That case was rejected by both the judge at first instance and by the Court of Appeal. So before I leave that point, I just refer you to paragraph 57 of Lady Justice Rose's judgment in this case, which is at core bundle, I think it's divider 7, page 215, and we say she got it right. Sorry, that's... That's right. And all she was doing there was summarising the principles, but all she was doing. She was correctly stating the principles which derive from the cases, and we say the law. My lords, sorry about that. Can I move on now to the terms of the two documents? And we say it is crystal clear from these documents, and no one could in any way have been mistaken, that there was no intention at all to retain the lien, or indeed any pre-existing security right. And the courts below were quite correct to reject any such suggestion. You've got the documents, I think, in the supplementary key documents bundle. And we say you have to read them together because they cross-refer and were entered into the same date. For example, clause 11 of the fixed fee agreement refers to the deed of charge. Just trying to find, yes, and clause 2 of the deed of security refers to the fixed fee agreement. So entered into the same day between the same parties and each cross-refer. Therefore, you have to look at them together. And if you look at clause 1 of the fixed fee agreement, it expressly provides that this agreement supersedes and replaces any previous agreement between Candey and PHRL in respect of fees. That's the end of it. There was no intention to maintain any agreement in respect of the fees, which predated this, these documents. Clause 4, what's being referred to as clause 4 of the deed of charge, makes the same point. Save for the deed of charge dated 25th March 2015 and related security, that's the Campion Maverick. In favour of Campion Maverick, PHRL warrants and agrees that he has not created and will not create or permit to subsist any other security or charge over the rights and monies protected by this deed. Again, clearly inimical to retention of any form of pre-existing security. It's worthwhile looking also at clause 3 of the terms and conditions, which are expressly referred to in clause 1 of the fixed fee agreement, which are said to apply subject to contradiction by the express terms. But clause 3 expressly retains the retaining lien. We are entitled to retain all purposes or papers until our fees are paid in full. That's an express retention of the retaining lien. There is absolutely no mention, either explicitly or implicitly, we would say, of the equitable lien.
Beg your pardon, where are you reading from now?
I'm reading from clause 3 of the Candey terms and conditions.
Thank you.
Do you have that, my lord? I think it's in the supplemental
Yes, I have.
bundle. I'm grateful. It's an express retention of the retaining lien, and nothing is said about the equitable lien. Now, much emphasis is placed by my learned friend on clause 7 of the fixed fee agreement. Again, the point is there is no express reference. And before I leave that, it's worthwhile mentioning, noting the previous sentence. There's express reference to Part 3 of the Solicitors Act 1974 and the assessment rights thereunder. Now, there is no reference to Section 73 of the Solicitors Act 1974. So the drafters were clearly aware of the client's rights to assessment under that Act, but made no mention of the solicitor's rights under Section 73. So above that, I'm now turning to Clause 7, I apologise. Any monies recovered by PHRL from the date of this agreement, we would say those are key words, and again they indicate that this is an arrangement which, looking forward, it's not intended to refer back to any pre-existing arrangement. and it refers to monies received from the date of this agreement. But of course, any monies are subject to the rights in the deed of charge. And as is made clear in the deed of charge, receipt of monies by Candey is subject to the pre-existing charge of Campion Maverick. And we say that Lady Justice Rose was entirely correct when she says at paragraph 90 of her judgment that the intention and effect of this clause is not to preserve any pre-existing lien, but is rather to reverse the position on appropriation and allow Candey, when it eventually gets sums pursuant to these agreements, to appropriate it to whichever debts it deems it wishes to. And that's the point. It's not in any way a reference to preservation of the pre-existing lien. I mean, if it is, it's hardly clear and manifest. I mean, even if you get there, which we say you don't, the very fact that we're having to debate in this court exactly what it means would we submit mean that it doesn't comply with the solicitor's duty, even if it isn't intended to preserve the lien, which it's not. It's not clear and manifest, such that a client would be sure or certain that the lien was being retained. There's then reference to paragraph 5 of the deed of charge, and my lords know that we've numbered them from 3 onwards, or 1, 2, 3 down. Again, there's no, and that's, say, paragraph 5 of the deed of charge, there's no express reference to the lien. Again, it's a new agreement because PHRL irrevocably agrees and instructs, so it's looking forward. There's no reference to past pre-existing security. It has to be read in the context of the deed of charge, and again, any rights which Candey have are subject to the prior rights of Campion Maverick. And again, as we point out, that is directly contrary to retention of the lien, which would be quasi-salvage. Paragraph 6 of the deed of charge, again, no reference to the lien, and again, the reference is to any monies and benefits covered by this deed and subject to this deed, and again, that's the deed of charge. So it can't be a reference to the lien. Again, it's purely a reference. All of this is a reference internally to the suite or the collection of rights granted in the deed of charge of the fixed fee agreement. There's nothing in that. And my lords, I know unless it's a standard form contract, my lords don't generally debate the words of individual contracts negotiated between the parties, but it is relevant here. But we say on the face of these documents, it is quite clear that there was absolutely no intention to preserve the lien or any pre-existing security right. And even if one could squeeze out of this, as my learned friend tries to, some obscure reference to the lien, it doesn't come anywhere near to complying with the solicitor's fiduciary duty, which we say is, in the words of Lord Justice Millett, to show clearly and manifestly, or show a clear and manifest intention to retain the lien. So far as anything that might have been said orally by Mr. Candey to Mr. Turnbull, first of all, well, paragraph 59 of the Court of Appeal judgment, which is at Core Bundle Divider 7, page 215, the Justice says this: there was then a protected negotiation discussion on the terms of the FFA and the deed of charge between the parties during September and October 2015. It is accepted by Candey that at no stage did anyone mention their solicitor's lien or suggest that there would be some security in place in addition to the deed of charge being negotiated. That was the position then, and we say it's still the position now. If Mr. Candey had indeed said to Miss Turnbull, oh, by the way, you know that Candey get their proceeds first, it wouldn't have been sufficient in all the circumstances to retain the lien or alert the client to the fact that they were retaining the lien, and it would have been directly contrary to the express documents they'd actually entered into, which showed that Candey weren't going to get the proceeds first. They were going to get their proceeds behind the charge of Campion Maverick. So we say there's nothing in the documents or in the surrounding facts which say that there was any reservation, whether express or implied. My learned friend, just while we're there, drew attention to the passage, paragraph 56 of the judgment of Lady Justice Rose in the Court of Appeal. And he criticised her for not dealing with inconsistency. That's an unfair criticism, because if you look back in context, what she's dealing with there at paragraph 50 is the point that my learned friend doesn't appear now to be making. Page 212. Mr. Lord submitted that Candey has a knockout point that renders most of the case law considered above irrelevant to the resolution of this appeal. He relies on the passage in Reed Taylor v. Morris and the two solemn decisions, which explain the reason for the lower threshold for inferring an intention to waive on the part of a solicitor entering into an inconsistent use security arrangement with his client, as compared with the threshold applicable to a bank or innkeeper. That lower threshold applies because of the fiduciary relationship owed by the solicitor to his client in respect of advice he gives about the effect of the new security. That somewhat quirky principle, that's a quote from Miller and Friends' submissions, has, he argued, no application here because Candey told Peake to obtain independent legal advice about the terms of the FFA and the deed of charge, and Peake did in fact obtain the advice of separate counsel William Frayne Bell, a barrister in charge opt. Mr. Lord points to clause 1 of the FFA where Peake confirmed and obtained independent legal advice. Candey was not providing this. So that's what she's dealing with there, which is the point that says is no longer appears to be made. My Lord, would this be an appropriate point for a break?
We'll adjourn then for 5 minutes.
Okay.
Yes, Mr. Holland.
My Lords, I'm going to submit now that the courts were clearly right to say that the lien had been waived. I think I've said all I need to say in detail, but there was clearly this was new security over the same property. The proceeds of the London litigation and the fact that it contained security over other properties, it makes no principal difference. There was new security with a different priority. Not only did it come below Campion Maverick expressly, as a floating charge, it would come beneath liquidation expenses. And liquidation was not unexpected. It was clearly foreseen or foreseeable, referencing clause 2 of the fixed fee agreement to the winding up petition which had already been presented by Jinpeng.
Can you just remind me, are floating charge holders always postponed to liquidation expenses, or is it only if the floating charge is taken at a certain time?
They're always.
They're always postponed.
Yes. Mr. Robbins, who knows a lot about these things, much more than I do, tells me that's the case. There was a different right to interest, which compared to what had previously been agreed, and there was a different mode of enforcement, as I've already discussed. Can I just analyse, I'm sorry, I was just going to analyse briefly the independent legal advice that was actually taken, because some point is made on that. We say it's quite clear that at no time, and it's accepted, did Candey ever expressly inform, or indeed by implication inform, either PHRL through Miss Turnbull, Mr. Judge, or Mr. Frayne-Bell that it intended to retain its lien. There's no mention of it, and we've been through the agreement. And we submit that as a matter of law, that's the end of it. We say, for what it's worth, in paragraph 162 of our written case, which is at Core Bundle 179, in answer to the access to justice point, we say a number of things, but we say, one, it's not exactly difficult for a solicitor expressly to retain his lien if that's what he or she intends to do. And secondly, it's prayed in aid the increasingly complex structure of litigation funding. And we say that if that is the case, and we acknowledge that's the case, litigation funders are a creature of the last 20 years or so. If that is the case, then it is all the more important for solicitors to make it crystal clear to their clients and to the litigation funders exactly what security they intend to retain and how it relates to the security to be taken by a litigation funder or by anybody else for that matter. So we turn that point against the appellants. So far as the advice in this case is concerned, clause 1 of the fixed fee agreement is pointed to, but that as reflects the facts, if you look at the email exchanges, all that is said there is that the client has taken advice on the fixed fee agreement. Now, I accept that our overall submission is that you have to read both the fixed fee agreement and the fixed fee agreement as deed of clause together, but there is a difference, a dichotomy in definition between the fixed fee agreement on the one hand and the deed of charge on the other, and the express recital in clause 1 of the fixed fee agreement is they've taken legal advice in respect of this agreement and not the deed of charge. And indeed, if you look at the email exchanges, and we've set them out, we haven't set them out, we've drawn your attention to them, it is quite clear that the advice given by Mr. Frayne-Bell was on the fixed fee agreement. And indeed, if you go through the email exchanges and look at the attachments, at no stage is any draft deed of charge ever sent to Mr. Frayne-Bell or Mr. Judge. So at the end of the day, in this case, it matters not that independent legal advice was taken. The duty of the solicitor is to make it clear to his client whether or not he intends to retain his lien. He should do so in clear and unambiguous terms. And the mere fact that the client gets independent legal advice is not by itself sufficient. The solicitor would have to make it clear to the independent legal advisor that that's the case. I mean, one can foresee a circumstance, I suppose, where the independent legal advisor gets to look at the deed of charge and the fixed fee agreement and says, well, looking at this, I think they're waiving their lien, they're not retaining their lien, I don't know. I could ask them. I could ring up Candey and say, well, do you intend to retain their lien? In which case they say, oh yeah, sorry, yeah, we do intend to retain our lien, which will put the client in a less advantageous position than if they'd said nothing. The point that neither the client nor the legal advisor should be put in that position. The solicitor should make it clear to the client or the legal advisor that that's what's being done, and the fact that this wasn't done in this case renders the fact that legal advice was actually taken irrelevant. There's a fiduciary duty over and above any contractual duty. My Lords, that's all I intend to say on pre-liquidation waiver, unless my Lords have any questions. post-liquidation waiver. And as you'll see, our case is that even if the appeal succeeds and there was a lien existent at the date of liquidation, they have waived it, or I'll use that word, they have failed to rely upon it by stating it in their proof of debt, and that without more means absent an application to the BVI court, which has not yet been made. That's the end of it. They have waived it for the benefit of the creditors.
Is there any time limit on the application, on the subsection 2 application?
I'm not sure there is, but I suspect the longer you leave it, the
less likely you're going to get much
court.
help from the liquidator.
Yeah. Given
whose discretion is it? Is it the liquidator's discretion?
No, it's the court. There is one of the cases. If you look, we cite it's I think it's
Well, I assume
it's re-safety explosives.
It would end up in court anyway if there was a dispute about it, presumably.
Oh yes, yes. Oh no, it has to be the court that grants. I'm going to take you to the provisions, and the later you leave it, of course. On this side of the court, we would not be entirely surprised that if this appeal fails, then there will be an application. If one part of the appeal succeeds and this part fails, then there will be an application.
Well, this point wasn't actually decided by the Court of Appeal.
No, it wasn't. The first instance, well, we say it's clear. It's absolutely clear. It's agreed that English law and BVI law are the same for these purposes. In other words, there's no expert evidence required on BVI law. And indeed, if you look at the provisions, they are in slightly different format.
Are there no BVI insolvency rules?
Oh, yes, there are.
Oh, good.
I'm going to take you to them.
I just wonder why we're looking at the English ones.
No, let's go to... if we go to section 214, if you go to Authorities Bundle 31...
Page?
And it's page 821.
Thank you.
What I'll do, if I may, is take you through the BVI legislation and then briefly take you through the English, which we say is of the same effect. It's not very long, and I no doubt there's people in this court who are much more familiar with these than I am. But if you go to, I think it's, as said, 821, you will see section 214 of the BVI. It's the Insolvency Act 2003 of the BVI. Subject to subsection 2, if a secured creditor omits to disclose his security interest when submitting a claim in the liquidation of a company, he shall surrender his security interest for the general benefit of the creditors. So we then go to the definition of secured creditor, which is in section 9.2 of the Act, which is at 819. A creditor is a secured creditor of a debtor if he has an enforceable security interest over an asset of the debtor in respect of his claim. It's the word enforceable that my learned friend focuses on. One then goes to the definition of security interest in section 2.1, which is at 817. Security interest includes a charge and a lien. So it's a security interest over an asset, and the definition of asset is also in 2.1 back at 812. Asset includes money, goods, things in action, land, and every description of property wherever situated, and obligations and every description of interest, whether present or future or vested or contingent, arising out of or incidental to property. Now, there's a similar I'll take you to the extremely wide definition, British. So, a security interest includes over an asset, and an asset can include a lien over future or contingent property. You can put it another way. If you go back to section 9.2 at 818, or sorry, 9.1 rather, a person is a creditor of another person, the debtor, if he has a claim against the debtor, whether by assignment or otherwise, that is or would be an admissible claim in the liquidation. And then you go to admissible claim in section 11, which is 819. Subject to section 11.2, subject to section 12, the following liabilities are admissible as claims of the liquidation of the company, foreign company, liabilities of the company, foreign company or individual. And then you go back up to section 10.2, which is on the same page. A liability may be present or future, certain or contingent, fixed or liquidated, sounding only in damages capable of ascertained of fixed rules. We say it is quite clear from those broad definitions that the provisions of operative provision is section 214, compels a secured creditor, that is a creditor who has an equitable lien over contingent or future assets, such as Candey would have had if it had retained the lien, to disclose that in his proof. If he doesn't, then he is deemed to surrender his security for the benefit of the creditors. Briefly, if you look at the English legislation, we say is of exactly the same effect, slightly different. I can take you to it, but I'll give you reference. It's Rule 1416 of the Insolvency Rules 2016. That's at divider 32, page 823. The definition of secured, and that's the operative provision in the same way as section 214. If the definition of secured creditor and security are in section 248A of the Insolvency Act 1986. That is at divider 30, page 783. And property, with a similarly wide definition we would submit, is at section 436 of the Insolvency Act, which is at, again, divider 30, page 787.
Is there a similar requirement in the insolvency rules that the security be, quotes, enforceable, quotes off?
No, there's not.
Because that's the word on which Mr. Lord hung his hat, as far as I can.
That's right. But we rely on that on the basis that if the parties agree to the same, the word doesn't occur. It's the definition is 1416 refers to a secured creditor. And then the definitions are at 30. It's 248 is the equivalent English provision, which is at 783. And that simply provides a secured creditor in relation to a company means a creditor of the company holds in respect of his debt a security over property of the company. And again, if you keep your hands in 783 and then go to 819, you'll see the difference in wording. It's section 9.2 of the BVI. A creditor is a secured creditor of a debtor if he has an enforceable security interest. So the word enforceable
is a BVI word.
Is a BVI word. And we say it doesn't mean presently enforceable because it can't mean presently enforceable because the provisions apply to assets which are contingent and future assets. You can't have a presently enforceable security over a contingent or future asset.
If you haven't. Oh, I see, yes.
That's what the lien is. It's a currently existing security, but it's not presently enforceable because it's not enforceable until there are proceeds. And what all the word enforceable is doing is making express what is implied in the English statute, which is it's legally enforceable, it's valid. Doesn't mean it's presently enforceable.
You wouldn't need enforceable. Well, we don't in the UK, because it would be assumed that you're only talking about valid security.
Yes, yes.
So, but therefore one asks, well, why is enforceable there?
We say, well, my learned friend relies upon it as meaning presently enforceable.
Yes.
And therefore, well, in my submission, that can't be right. Given the rest of the definitions, you can't have a presently enforceable security over a future or contingent right. It's not presently enforceable.
So he says it's not enforceable.
Yeah, but that's right. Well, it's either between a rock and a hard place, because if it's not presently enforceable, such as not to be disclosable, then it doesn't exist. The court's not going to enforce it. And the Roberts Petroleum dicta, the waterfall crystallizes at the date of liquidation. Sentence I never thought I'd heard myself say in any court, but and therefore, and that's the Roberts Petroleum case, you either have a security at the date of liquidation, in which case you have to prove for it, you have to disclose it, because the liquidator has to know you're relying on it, or you don't, in which case a court's not going to grant you it afterwards. What my learned friend says is this is some form, the lien is some form of species of security, which, not being enforceable, presently enforceable, doesn't have to be disclosed, but nevertheless subsists and is enforceable before liquidation as well as afterwards. I mean, it may be, my lord, is somewhat hamstrung by the agreement of the parties it's set out in that order of Mr. Justice Hilliard, because the parties have agreed that the English law is the same as BVI law for these purposes.
Yes, but surely that wasn't meant to mean that if there was some express difference in part of the regime, the BVI one would be ignored, or contrary to how it should be construed in such a way that rigidly required it to conform with the differently worded English provision.
Well, my lord, foreign law is a matter of expert evidence.
Yes,
isn't it?
but well, okay.
Yeah. Well, Mylord Jr., who was present at the time, it was designed to stop the parties needing expert evidence on foreign law. I mean, I suppose my lord could read it as saying, well, I am free now to interpret the BVI statute as I would an English statute.
Yeah.
Andrew, I'm not sure the BVI lawyers would say that that's binding on them as a matter of BVI law.
I'm sure it also meant that you can look at English authorities, see what the underlying principles of the insolvency scheme are.
Yeah, well, it may be, but we say that the different wording, my primary submission is the different wording of the BVI Act.
Well, suppose that the English rule said you had to do something within 14 days, and the BVI rule said you had to do it within 7 days. What do? Construe 7 as if it meant 14?
No, my lord, I don't say that. But I say the underlying principles and the relevant definitions in both the English and BVI statutes mean that, particularly the definition of asset, mean that you cannot read, even taking the BVI legislation alone, you cannot read the word enforceable as meaning presently enforceable. I suppose that's a better submission on the words of the Act, even setting aside the English. I think we rely upon the English Act as being the equivalent, but that would be my primary submission.
We did look at this kind of issue fairly recently in the Brownlee case. What's it called? It was a Four Seasons hotel in Egypt being sued by the widow of Professor Brownlee. And we looked at the circumstances in which you could apply a presumption that foreign law and English law were the same, and it was heavily qualified. You would have to look at the judgment, but it was heavily qualified where you were looking at technical legislation.
Well, my lord, I'm afraid I'm not familiar with that case, and I apologise for that.
I thought it had been conceded by the appellant that this charge lien was presently enforceable in the sense that you could maintain an action for an injunction, prevent somebody from interfering with it.
I'm sorry, my lord. I was looking at I've had a communication, but I'm sorry.
I thought it had been conceded by the appellant that the lien or charge was presently enforceable. Not in the sense of actually recovering the money from it, but preventing other people from interfering with it.
Yes, my lord, we say it's not presently enforceable, but it's present. For example, if, and I think there was some exchange between from Mr. Lord and Lord Briggs, I think it was, as to what the status of the lien was. Well, if, for example, even though there were no, for example, if you had litigation in England over the ownership of a house, and that became the proceeds of sale, suppose prior to the end of that litigation, the solicitor got wind that the client was proposing to dispose of the interest in that house, such disposal would adversely affect its lien, then in my submission, the solicitor would be entitled to go to court and apply for an injunction. I think that's the point. I hope that's the point. That it's a presently existing right over an asset which has yet to vest. Mm. And it's presently enforceable in that way. It's an existing right. My primary submission is that enforceable simply means valid or subsisting. And the whole point is that standing back, as Mr. Crumpler makes clear in, I think it's paragraph 10 of his witness statement, the whole point of this is to allow the liquidator, who has statutory duties to get in the assets of the company for the benefit of the creditors in the order of the waterfall, to know whether a particular creditor, how much the creditor says the company owes it, and whether it has security for that, and whether it relies on that security.
It's also denied to enable the liquidator to redeem it if he thinks he can do better with the underlying asset than the secured creditor has in his valuation of it.
But that's right, and not only that, but there's nothing. I think the learned friend also relies upon that in his written case. But if you look at,
well, that might be a point in your favour.
Well, yes, that's right. There's nothing wrong. We say there's nothing unusual about a valuation of a contingent or future asset. It's especially it's paragraph. I think it's rule 1414 of the insolvency rules in this country, and section 1523 of the BVI Act, which I think is one of the documents which was passed up. So the statutory provisions in both jurisdictions expressly provide for valuation of contingent or future assets. And so there's nothing wrong, there's nothing unusual about that, because my learned friend spends some time in his written case going on about how it can't be said, how can you put a value on a contingent asset? Well, it may be
all the time. But
yeah.
Yes.
And you would say, who better than the solicitor with the conduct of the litigation?
Yes. So we say that they failed to put it in their proof, even if they had it at the date of liquidation, that they've abandoned it, and that's the end of it. And the courts, the first instance judge was wrong to apply the some sort of constructive notice provision, because it's nothing to do with constructive notice. It's statutory provisions in both jurisdictions, the purpose of which is quite clear. And there's nothing. Candey relies on a statement of Mr. Justice Henderson, as he then was, in one of the remarks on the London litigation. It's paragraph 125.8 of their written case, divider 5, page 130. It's one of the hearings, the interim hearings in the London litigation, which the report is at the authorities bundle 881703, and it's paragraph 981739. But we say, if you go to that, that was a case. It was made. The remark made by Mr. Justice Henderson was a completely different context. He held that the monies in court paid in to fortify the undertaking as to damages were not available as security for costs. He wasn't considering whether the monies in court were an asset so far as the lien was concerned. Indeed, if one looks at the Court of Appeal ruling in what's known as the New Monies Appeal, which was to the effect that PHRL retained the property in the monies in court, he could therefore subject them to the charge. So there's nothing in what Mr. Justice Henderson says in that case which would undermine this post-liquidation waiver point. Candey also relies on the statement of Lord Millett in Re Park Air Services. That's divider 22, page 664 at 678, to the effect that the landlord's right to forfeit isn't security. Again, that's got nothing to do with this particular circumstances. The landlord's right to forfeit is completely different from a solicitor's lien. The solicitor's lien, as Lord Briggs has held in the Haven case, is an equitable charge. And Lord Millett held in Park, all Lord Millett was holding in the Park Air Services case was that a landlord's right to forfeit a lease was not such a security. And attempts by Candey to try and row back from the fact that they had a security such that they had to disclose it rather undermine their case. As we said, either they had a security, in which case they had to disclose it, or they didn't, in which case they didn't have one and it won't survive the liquidation. And there's no reason in principle, we say, why solicitors should be treated any differently from any other creditor.
Yeah. I mean, that seems to be the implication of the submission, that that if legislation in a BVI confines enforceable securities to those that were enforceable as at the commencement of the liquidation, and this one doesn't count, therefore, a lien over the yet to be received proceeds of litigation isn't enforceable, then the implication would seem to be that the liquidator is entitled to distribute the assets regardless of the lien.
Yes, but even worse, at some stage, at some future point, when the liquidator has worked on the assumption that there isn't a security, the solicitor is entitled to pop out of the woodwork and say, oh, by the way, I have my solicitor's lien, which trumps everybody. And you see that distribution that you made, you've got to recall it because I had prior dibs on the money.
I mean, the proof of debt is to enable the liquidator to adjudicate on the value of the claims for the purpose of distributing the assets.
Yes.
Or any surplus, anyway.
Yes, and there's nothing inimical about this. The solicitor or the creditor and or the liquidator valuing or attempting to value a contingent or future claim.
And subject to redemption, the valuation, there is provision to adjust the valuation, isn't there?
Oh, there is. There's various provisions which.
Unless it's been redeemed, it can be revalued.
Yes.
Yeah.
That's right. Mr. Robbins is nodding, so I'm safe to agree with you, my lord. My lord, I now propose to turn to my last topic, which is abuse of process and the exercise of discretion. I don't propose to detain you long on this because we've set out our case in some detail in the written case, and you only get to this if we lose on both of the other grounds. But we do maintain it because we say the way this has been done is an abuse of process. Now, I accept, and the facts are set out in Mr. Crumpler's statement, paragraphs 17 to 19, 58 to 9, 89 to 91, and 97 to 116. And that's core bundle divider 7, pages 325, 334, and 338 to 342. But
334 and what, sorry?
So 338 to 342, my lord. And it's the delay in mentioning the lien between March 2016 and March 2018. And in that period, the parties had litigated in the courts here about the nature of the security which the solicitors claimed to have. and that was the deed of charge and the fixed fee agreement. And that involved 2 substantial hearings in the Chancery Division and 2 trips to the Court of Appeal. And I think we estimate about £2.5 million worth of costs were spent litigating over A, the status of the deed of charge and the fixed fee agreement, and secondly over how much was, once it was held to be a floating charge rather than fixed charge, how much was secured by it. And we say that then the solicitors then came out of the woodwork and said, oh, we've got a lien, which renders all of this completely meaningless, because we have and have always had security which trumped it. I mean, another jury point, they're still at it. They made an application subsequently in the BVI courts to have the fixed fee agreement treated as a liquidation expense. That failed, and they'd failed permission to go. But that would be another attempt to rely upon a security in a different way. Now, we say in those circumstances this is a Henderson-type abusive process. I accept that this court has, last year, in the franked investment income test case, given a further view on abusive process. But we say there's 3 elements come across, and that there's 2 relevant judgments in this court. There's the Virgin Atlantic Airways case, which is at divider 28 of the bundle. It starts at 740, but it's paragraphs 17 and 24 in the judgment of Lord Sumption at page 760 and 764. And that is summarised and glossed slightly in the franked investment income test case, which is at divider 95 of the authorities bundle, page 1895. It's paragraph 60 at 1916 and paragraphs 74 to 77. Now, I accept, as I have to, that I think the franked, as I read the franked investment income test case, it emphasised that it's quite a high bar for abusive process. That was a case where I think the revenue wanted to withdraw a concession and argue about a limitation period. I don't begin to understand it's tax law, so nothing I know anything about. But what I think the 3 points we would submit that are relevant are as follows. 1, whether or not something is an abusive process is a broad merits-based judgment which takes into account of the public and private interests. Secondly, of course, it takes into account all the facts of the case. Thirdly, it focuses on whether the party said to be abusing are misusing or abusing the processes of the court and oppressing the other party by raising matters which they could and should have done earlier. And that applies in earlier proceedings or earlier in the same proceedings. Are they effectively trying to have a second bite of the cherry? And we say that's the case here. Now, I accept there's a temptation to look at the counterfactual and say, well, Mr. Holland, what would have happened? They would have raised the lien, and your clients would have disputed that they were entitled to it. Then they would have gone to the charge. So it might be said that the same thing would have happened, but in reverse. We would submit that you should resist that temptation, because you have to look at what's actually occurred and not what might have occurred. But as my Lord Briggs said in answer to my learned friend, or in discussion with my learned friend, had they said, look, we have 2 securities here, right at the outset. We've got the lien, and we've got the fixed fee agreement and the deed of charge. We rely upon each of those, and then it was said, all right, well, the case could have been properly managed, heard, tried together, and we wouldn't have had the same level of expense as importantly, the same level of delay. My clients are liquidators. They have a statutory duty to get in the assets and distribute them to the poor old creditors. And at the minute, we've been delayed by arguing constantly with one particular creditor. And the courts are, in my experience, very big on the CPR in managing cases and trying to get litigation over with as cost effectively and as quickly as possible. And had the counterfactual is that had they, right at the outset, maintained or said that they have they held the security, both as the lien and the fixed fee agreement and deed of charge, then the case would have been managed differently, and the delay would have been considerably less, and the costs would have been less. And in those circumstances, on the facts of this case, we say that is abusive behaviour, and they should not be allowed to raise the lien argument.
I haven't been able as yet to read those authorities you just referred us to, but the ability to strike out a claim for abuse of process is both under the inherent jurisdiction and under the rules of court.
Yes, I think it's normally held to be inherent. It's some argument whether it's a procedural rule or a rule of law. I think that it's held that the Henderson jurisdiction is a procedural rule inherent in the court to prevent abuse of its processes.
There is a rule that permits
there is a rule in the CPR, yeah, I think 3.1 of the CPR. I normally have it here, but I don't think...
It uses the word may.
Yes, oh yes, yeah.
Is it evaluative or discretionary?
It's evaluative in the sense that the court has to look and see whether in its view it is abusive. But once it finds it's abusive, there's no discretion not to strike it out. That's what I'm saying.
Why do they use the word may in the rule?
Well, I would say that that would reflect the evaluative nature of the right, in the sense that simply because I say there's an abusive process doesn't mean there is one. But once the court finds that there is an abuse, it should normally be duty bound to strike the case out. I never like telling any court that they can't do something. I might say that they on the facts they shouldn't, but I don't like saying you've no jurisdiction to do something. But there may be circumstances then, my lord, when despite the fact that the court might find that a party has abused the process, and the court nevertheless they won't strike it out. But my primary submission would be that if the court finds that there has been abusive process, then it should strike the claim out. It shouldn't countenance its procedure being abused in the way which we say Candey have done. I hope that's an answer to my lord's question. It may not be a satisfactory answer, but I hope it's an answer. My lords, we say in the broad merits-based judgment, the lien application should be struck out. We make the same points under Section 73. Section 73 indicates, and again, it's right that under Section 73, my lord, that, let me find that, it does indicate that there is a discretion in the court whether or not to enforce the charge, the security. If you go to, find it for you, it's divider 29, page 778. Subject to subsection 2, any court in which a solicitor has been employed to prosecute or defend any suit, matter or proceedings may, at any time, declare the solicitor entitled to a charge on any property recovered or preserved through his instrumentality for his costs in relation to that suit, matter or proceeding. I mean, just to break off this, where I think Lord Briggs and I had a discussion yesterday about the ambit of Section 73. I think that's where we derive I was making the submission, as you recall, that the solicitor's lien covers only the costs of the English proceedings, and I think that's the words that we derive that from, but I don't need to make the point.
Actually, if it's of any assistance, in relation to the issue that was just raised by Lord Stevens, the point was dealt with at an earlier stage of the FTT saga, and you'll find it on page. Heavens, I can't read the last digit, but if you go to tab 94.
Yes, my lord.
And it's at paragraph 75 of that judgment. It's 181 something or other. Well, the court said that while the concept of abuse of process informs the exercise of the court's procedural powers, it is not a question of the exercise by the court of a discretion.
As I have that highlighted and underlined, I assume that my answer came from my knowledge of that, but as usual, I wasn't able to remember that, but that's where I think I got it. Or I'm assuming that having highlighted it, I've read it. I'm grateful. I don't think that's any different from the submission that I made to...
No, it's not.
I'm grateful. I've taken you to section 72, and simply this, the courts have repeatedly stated, albeit courts lower than this court, or its predecessor, the House of Lords, that the court has a discretion under section 73 whether or not it will grant the relief sought. And that's reborn, which is at divider 6 of the bundle 437 at page 439. Refold, that's the judgment of Mr. Justice Scarman at divider 60 of the authorities bundle 1217 at 1227. Fairfold Properties, that's 58 1198 at 1206. Mr. Nugee QC said the same in Clifford Harris number 2, that's divider 10 490 at paragraphs 22 and 23, 503 page. And I think the judgment of Lord Briggs in the Haven case, I think mentions it briefly at paragraph 57, which is at divider 14, page 564. Now, I accept that having emphasised that there is a discretion, the courts have said, as did Mr. Nugee especially said, normally that discretion should be exercised in favour of the solicitor. And I accept that in none of those authorities did the court refuse to exercise its discretion. I think in Refold, which was the Wills case, it refused to do exactly what the solicitor wanted, but granted a similar type of relief. But the facts there are very different from the facts here. And essentially for the same reasons as I would submit that this is an abusive process. This court should say that any discretion should not be exercised in favour of the solicitor. Now, insofar as the judge, the Court of Appeal said nothing about this, so there's no exercise of discretion or appeal. Insofar as the judge at first instance exercised his discretion, he did so at paragraph 150 of his judgment at divider 7 of the core bundle, page 287. It's very brief. And we would submit, paragraph 150, we would submit that he, insofar as he exercised discretion, he exercised it wrong. He was wrong to conflate the issues of abusive process and discretion. I accept I rely on the same facts to make it out, but they are two separate jurisdictions, and he appears to have conflated them. Second, his decision on the exercise of his discretion was based on his ruling in relation to the abuse of process. And again, perhaps the same point, other side of the same coin, he should separately have considered.
If you don't succeed on abuse, what do you say is also relevant to discretion? Why should it be a different decision?
It's a separate
Yes.
jurisdiction. And I say that you couldn't take into account separate terms. And one is an abuse of the process of the court. And so you have to consider the court's procedures and whether the party said to be abusing it is misusing the procedures of the court. You're not trammelled in that way by Section 73. You simply say, well, in all the circumstances of the case. I accept, in reality, if you're unsympathetic to the factual basis of my argument on abuse, you're unlikely to be sympathetic to my submissions on discretion. But it is technically a different jurisdiction. I
suppose in theory a court of equity might decline to enforce a purely equitable charge on some kind of laches related basis on the footing that there'd been delay coupled with prejudice. It's not mere delay.
Yes. Well,
but I'm not aware of any case in which that's ever been done.
No, nor am I. But I mean, I would say I don't have to rely technically on the equitable principle of laches, and I haven't done thus far. But that similar considerations, I would say, apply in relation to the discretion under Section 73. And the point is, as the Supreme Court has said in Virgin case and in the, I've forgotten the name of the case now, the tax case, you have to consider carefully when you're exercising the abuse jurisdiction, you have to carefully consider whether in fact it's an abuse of the process of the court, and there's an incrustation of learning around that, whereas there's not such you're not so trammelled, we would submit, in that way, in exercise of your discretion under Section 73. There is no case that I can point you to where the court has said, in the exercise of my discretion, I'm not going to, but there must be a discretion, and there must be cases when it's appropriate to exercise the discretion and refuse. And you can rely upon not only facts which might evidence an abusive process, even though you might say, well, actually, technically it's not, because we've got to look at what this court have said in past cases, or you might look at things that, well, even though the equitable defence of laches is not relied upon technically, I can look at similar circumstances or similar facts and refuse to exercise the discretion. So it's a different jurisdiction, and it's not so circumscribed by authority or perhaps legal principle as the abusive process doctrine is. But quite frankly, I hope I'm being realistic in saying that if my lords are unsympathetic to the factual basis of my abusive process claim, you are unlikely to think, well, despite the separate jurisdiction, we're going to exercise our discretion or not. But these are firm solicitors, and look at the way this has been gone about. Part of their case, which I've described as the any fool know bit, is that everyone should know that the solicitors have a lien. That's their case on constructive notice in the post-liquidation waiver point. Well, if that's the case, why didn't they raise it? And you are entitled to say, given the position of the solicitors, that this is a statutory provision expressly for solicitors, then if they want that sort of relief, they should apply for it timeously and in an appropriate manner. My lords, I think those are my submissions on everything. I'm grateful, unless my lords have any questions.
It appears not. Thank you very much, Mr. Holland. Mr. Lord.
Well, my lords, first, just one housekeeping matter. As I suggested, and you'll have seen that there's a daily transcript. I just wanted to check that your lordships have received it.
Yes, we did. Thank you very much.
But my lords, it emerged from Mr. Holland's submissions that there is, in fact, I think, an even larger measure of common ground between us than appeared from the cases which I addressed yesterday. Mr. Holland's position is that it's right that a uniform approach is taken to waiver of all security interests, whether arising by operation of law or in equity. We agree. However, he suggested that principles of waiver by election should not apply. And with respect, it's not clear to us why that should be, especially in circumstances where the Court of Appeal itself appeared to take that as the starting point, namely that any waiver of rights requires an unequivocal representation and knowledge. That's set out in paragraph 35. And in the same paragraph, the Court of Appeal found that an unequivocal representation can arise by conduct, including taking a security which is prima facie inconsistent with the retention of the lien. So there's no conceptual disconnect between the principles of waiver by election, or waiver generally, and the approach one sees in the authorities that we've looked at in the context of the solicitor's possessory or equitable lien. It's the same exercise and has a test which is worded very similarly: unequivocal representation or clear and manifest intention. What is lacking from the authorities, and I don't want to repeat what I said yesterday, is any consideration of the requirement of knowledge. And this is the point we make in paragraph 44.2 of our case. As I said yesterday, one can see that in a vendor's lien case, that there will not be an issue as to knowledge. The vendor knows what the property is, he knows the terms of the sale, he knows what he's entitled to receive. The same for the possessory lien. The solicitor's holding on to the title deeds, but if at the same time that he's holding on to the title deeds, he seeks and gets from the client a promissory note payable in 3 years' time with interest of 5%, then one can see that one can readily infer from those facts that he's decided to rely upon the promissory note and not on his possessory lien, and therefore is not entitled to hold on to it. But the position is different in relation to the equitable right, because Candey, at the time that the deed of charge was entered into in October 2015, didn't know what recoveries were going to be made, didn't know the value, if I can put it like that, of the equitable right, didn't know whether or not there was going to be a settlement, didn't know whether or not the matter was going to proceed to judgment and PHRL was going to be successful. And if it was successful, what would the terms of the order following judgment be? The claim was partly for the shares in that were the shares under which the Amman resorts were held, and also for damages. Furthermore, insofar as there was an award of damages, Candey didn't know whether or not the defendants were going to be good for the money, whether or not they'd be able to enforce. So that's why, in our submission, knowledge is potentially relevant in cases concerning the equitable right, if the charge is entered into before there have been any recoveries. Because in those circumstances, how can the solicitor know what he's waiving? He can't.
Well, he knows he has a right.
Of course he does. Yeah, he knows he has the equitable right, but he doesn't know what it's worth. And even if that's not an absolute requirement, we do rely upon it for saying, look, in those circumstances, you've got to be very careful at inferring an intention to waive. Because in effect, what is being said is that Candey have waived something that they didn't even know the value of. My Lord, as I understood Mr. Holland's submissions, first of all in reply to Lord Hamlin, and then in reply to Lord Stevens yesterday afternoon, and then today in reply to Lord Briggs, he accepted that there was a two-stage test and that the relevance of any fiduciary duty or duty of disclosure only arose in relation to the second stage. So that the first stage is the objective exercise of seeing whether or not one can infer an intention to waive from an inconsistency, and it matters not whether or not the person who's said to waive is an innkeeper, banker or solicitor. It simply doesn't matter. Mr. Holland accepted in terms that an express reservation would trump inconsistency, whether or not you're dealing with a solicitor or anybody else. So it follows that so long as the solicitor expressly reserved the lien, then he will do so. He will have reserved the lien, and any inconsistency doesn't matter. And if Lord Stevens is right that you cannot imply a reservation, and we do still submit that you can, relying upon Lord Justice Buckley, but I accept that there's comments in other cases, particularly Mr. Nugee in Re Solent. But if, in fact, the difference between a solicitor and an innkeeper is that because of the fiduciary duty and the duty of disclosure, you cannot imply a reservation, then again, the duty of disclosure itself doesn't have any application. It is simply a factual inquiry. Was the lien reserved? But in considering the duty of disclosure at the second stage, I just want to make 3 points. First of all, that test arising only at the second stage is different from what Lady Justice Rose is saying in paragraphs 56 and 66 of the judgment. Now, I think Mr. Holland would say, in defence of Lady Justice Rose, that paragraph 56 is only dealing with the question of reservation, not inconsistency. Well, if that's right, then that does away with one of my concerns about section 56. But my secondary concern is that Lady Justice Rose formulates the test as a more burdensome and higher test than simply looking for whether or not there's been an express reservation. So she refers to an obligation to explain in a clear and intelligible manner in the combined effect of the new security and the lien on the prospects of the client recovering anything. The client should be made aware that even though he's now been asked to grant security over the litigation recoveries, the solicitor will still have a first call. It is essential that in making that choice he has a complete understanding of what his solicitor's prior claims to the proceeds of litigation will be if he continues to fight the case and thereby incur further fees. My Lords, in my submission, that goes too far. It's not the second stage of the test. The second stage of the test is simply, was there a reservation of the equitable rights under the lien? My Lords, then, turning to the first stage, it's important to bear in mind the principle behind the equitable rights, namely access to justice. That is precisely what Candey were facilitating. Without their agreement, PHRL would have been denied access to justice. As is mentioned in the authorities, waiver is not to be easily inferred. There must be a manifest and clear inference, which is similar to the unequivocal representation. And when one looks at the position in October 2015, it would be very surprising if Candey had intended to waive their lien. They were just concerned to get as much protection as they possibly could, as Mr. Candey explains in paragraphs 17 and 18 of his witness statement. My Lords, as far as independent legal advice is concerned, it's only relevant. Well, it has two potential relevances. One is it could be a knockout blow. That appears to be what Lord Justice Shyman is saying in Twig Farnell. It doesn't appear to be what Lord Justice Mummery is saying, because he finds that there was no inconsistency first. If that's not right, then the relevance of the independent legal advice is to any distinction that your lordships say exists between the position of a solicitor and any other lien holder when one comes to the question of reservation. Now, in my submission, there is no distinction, because what is it that should be disclosed if there's a duty of disclosure? What should be disclosed? The answer is that you're reserving the lien. Well, that's precisely the question that would arise in the case of a banker or an innkeeper. But in my submission, we've got to the position in relation to independent legal advice that it is only potentially relevant to the second stage, and then only relevant if the question of reservation is treated differently in the case of a solicitor as opposed to anybody else. And if it is, in my submission it shouldn't be, but if it is treated differently in relation to a solicitor, then it definitely shouldn't be, where that solicitor has told the client, and the client has confirmed that he's taken independent legal advice. My Lords, as far as the 4 inconsistencies are concerned, I don't want to repeat what I said yesterday. I'm just dealing with the points made by my learned friend. First of all, as far as the same property is concerned, as far as the reference to Mr. Justice David Richards in Solon number 9, Solon number 1 in paragraph 23, in my submission, there is no reason why a charge over the same asset should inevitably give rise to an inference that the lien's been waived. There's no reason why a charge over the same asset and the lien cannot exist in parallel, and no reason for finding that they're incompatible. But here, and that is consistent with the finding, with the judgment of Lord Justice Mummery in Twig Farnell. Because although my learned friend seeks to get round Twig Farnell by saying, well, there, what had happened is that the claim to costs had merged in the judgment, and it was the judgment that the solicitors obtained a charging order in respect of. Yes, factually that's correct. But the question is, what is the charging order over? Answer, the same asset, the property. So that Twig Farnell is the only case in England which considers additional security over the same property. Lord Justice Mummery, quite rightly in my submission, says no inconsistency. In our case, as your lordships know, we are not in that territory. It is not a case whereby the deed of charge covers the identical property to that that's covered by the equitable right. Your lordships know that the deed of charge covers all sorts of other things, all of the assets of PHRL, all the recoveries in all the litigation worldwide, etc., etc. And in my submission, therefore, it is impossible to infer from that that there was an intention to waive the equitable right. My Lords, I'm looking at the time. I don't know if you... I mean, I could probably finish in 15 to 20 minutes, but I might not, depending upon any questions from your lordships. I don't know if you'd rather rise now. Or...
I think we rather would. We'll resume at 2 o'clock.